Hello and welcome to this talk about the effect that early conciliation has had on the Employment Tribunal rules. My name is Declan O'Dempsey. I'm a barrister at Cloisters Chambers. Before turning to the changes themselves, I just want to recap on the requirements of an early conciliation certificate. This has to have the prospective claimant and prospective respondent's names and addresses, the date Acas received the form or the date the prospective claimant telephoned Acas, a unique reference number given by Acas, the date of issue, which is the sending of the document by Acas, and the statement of the method of sending. Acas has to send the early conciliation certificate to the prospective claimant, and if Acas had contact with the prospective respondent during the period, then the prospective respondent. In each case, the service will be effected either by email when it's deemed to be received the same day, or by post when it's deemed to be delivered in the ordinary course of post. The preferred method is by email, and that's the way it will be served if an email has been provided. So when is it not obligatory to use the conciliation procedure? In another talk I've dealt with the circumstances where you have to engage in early conciliation, and that involves considering whether the proceedings are relevant proceedings, which means that they're on a list which I've set out in the other talk. But even if the proceedings are relevant ones, the prospective claimant can still institute proceedings without contacting Acas and going through the process of early conciliation to whatever extent, in cases which are prescribed in the early conciliation rules of procedure rules. Rule 3.1a states that if somebody else has complied with the Acas requirement in relation to the same dispute, and the prospective claimant wants to institute their claim on the same claim form as that other person, then the prospective claimant doesn't have to comply with the early conciliation requirements. Rule 3.1b states that if you institute relevant and non-relevant proceedings on the same claim form, then you are able to do that without having gone through the early conciliation procedure. Rule 3.1c allows the prospective claimant to show that the prospective respondent contacted Acas over the dispute and Acas has not received the prospective claimant's information, that's the name and address, in relation to that dispute. So it's most likely to be the address that is missed off in most cases. However, the employee must also in this case show that the proceedings on the claim form relate to the dispute over which the employer contacted Acas. By Rule 3.1d, in unfair dismissal cases where the application to institute the unfair dismissal proceedings is accompanied by an application for interim relief, then the requirement to go through early conciliation does not apply. And then finally, under Rule 3.1e, security cases are exempted. The Employment Tribunal rules have been amended to reflect the requirement for claimants to engage in early conciliation, so that under Rule 10.1c now, an Employment Tribunal must reject a claim form if it does not contain one of the following: a unique reference number, confirmation that the claim doesn't institute any relevant proceedings, or confirmation that one of the exemptions applies. Where it's rejected, the form is returned to the claimant with a notice explaining why it's been rejected. And by Rule 13, this must include information about how to apply for a reconsideration of the rejection. But you should note that the impact of that return may be quite substantial. The date of the presentation of the claim will be the date when the reserved claim form is presented with the defect cured. And that may mean that the time limit has expired. I'm going to talk about time limits a little later on. So what happens if the Employment Tribunal staff are not sure as to one or other of those elements being present? Staff in those situations must refer the claim form to an employment judge if they consider that the claim or part of it may be one which institutes relevant proceedings, and the claim form on which the claim is made lacks a unique reference number or confirmation that an exemption applies. The employment judge will then consider those factors and reject the whole or part of the claim if the employment judge considers that the claim or part of it does not have a unique reference number or confirmation that an exemption applies and that it institutes relevant proceedings. How often will this be used, however? Because a unique reference number is an all or nothing question. Either the claim form has it or it doesn't. And one of the exemptions is where there is a mixture of relevant and non-relevant proceedings in the same claim form. So it's difficult to see how part of the claim can be rejected. It may be that it's possible to identify two sets of relevant proceedings in the same claim form, in respect of one of which early conciliation has been undertaken, and yet in respect of the other early conciliation has not. But it does seem to me that it may be quite rare for the employment judge to be able to allow through only part of the claim. Rule 12(1)(e) and F of the Tribunal Rules deal with particular bases for rejecting the claim form. So the claim form will be rejected if it institutes relevant proceedings and either the claimant's or the respondent's name on the claim form is not the same as the prospective claimant's or prospective respondent's name on the early conciliation certificate to which the unique reference number relates. Now there is one exception that the rules make. The claim form will not be rejected if an employment judge considers that the claimant made a minor error in relation to a name or address and that it would not be in the interests of justice to reject the claim form. It should be noted that a mistake in relating to the address does not trigger the Rule 12 rejection in any event. In the case of all Rule 12 rejections, the claim form is returned to the claimant together with a notice of rejection, which will include the employment judge's reasons for rejection and informing the claimant about how to apply for reconsideration. Two of the exceptions are of interest. The first of these is where you have multiple claimants on a claim form. Here, the prospective claimant benefits from the effect of early conciliation on, for example, time limits and may get an extension of the time limit due to another person's use of Acas for the same dispute, but only where both persons are making the claim on the same claim form. One of the exceptions, and the other one of interest, is where the claim is made on the same form as somebody else in relation to the same dispute. But there is no definition of dispute. It may, for example, just mean the same set of facts, or it could mean the legal dispute between employer and employee, so that there would be a difference between a claim for redundancy and a claim for unfair dismissal for unreasonable selection for redundancy. How will the Employment Tribunal be able to tell if the dispute is the same dispute? Well, the idea behind the system of early conciliation is not to create an obstacle as such, but to encourage a sensible early settlement of cases. So I think that an informal approach will be adopted, and the same set of facts will give rise to the same dispute. The alternative, which relies on the same dispute involving the same legal cause of action, is unnecessarily obstructive. Early conciliation can have an effect on the application of time limits. If the primary time limit falls before the prospective claimant contacts Acas, then the conciliation period has no effect on the Employment Tribunal's consideration of when time expired. In those circumstances then, if the time limit has expired, the prospective claimant should contact Acas immediately to start early conciliation, because claims made after the time limit still need the early conciliation certificate for the claim form, the ET1, to be completed validly. The claim form will be rejected by the Employment Tribunal unless there's a compliant early conciliation certificate, or the claim doesn't need one. So how do early conciliation provisions affect time limits? There are many time limits that are affected, and a couple of examples are the Employment Rights Act, section 111. Now there is section 111 2A, and equally in the Equality Act 2010 there is now section 140 B, but there are many others. What happens is this: in ascertaining when a time limit which is set by a relevant provision expires, the Employment Tribunal will not count the period beginning with the day after first contact, so that's the telephone call or the filling in and sending of the form to Acas. That first contact day is known as day A, and ending with another date which is known as date B or day B. So day A is the day on which the prospective claimant complies with early conciliation requirements in relation to the matter in respect of which the proceedings are brought. And day B is the day on which the prospective claimant receives, or is treated as receiving if that's earlier, the early conciliation certificate. There are two different effects that need to be looked at. We're now looking at the effect of not counting certain days. So take an unfair dismissal case where the employee is dismissed on the 7th of May and makes contact with Acas the next day on the 8th of May. The Acas officer tries for an extended period, which can be up to 6 weeks to settle the case, but gives up on the 12th of June. So the claim is then presented on the 5th of September. The day after day A is the 9th of May, because day A is the date on which the employee made contact with Acas, and day B is the 12th of June. Now that period is not counted for the purposes of ascertaining when the time limit would expire. The time limit would otherwise have expired on the 6th of August, but because it's necessary not to count 9th of May to the 12th of June, the claim is presented within the relevant time limits. There is an effect if the ordinary time limit would expire in the period which is from day A to day B plus 1 month. So for example, in unfair dismissal cases, if the time limit would expire in the period day A to day B plus 1 month, then the time limit is deemed to expire at the end of the period B plus 1 month. So, for example, suppose I'm dismissed on the 2nd of April 2014. The time limit would expire 3 months minus a day after that, so the 1st of July 2014. But day A, so that's the day when I make contact with Acas, is the 28th of June. Now suppose the conciliation officer tries to effect a settlement for a month, then day B plus 1 month is the 28th of August 2014. How does early conciliation affect extensions of time limits? The rule is that where there is a principle permitting extension of a primary time limit, such as 3 months from an act of discrimination, but there's the principle that the Employment Tribunal can consider the claim brought later than that if it considers it just and equitable to do so, then the Employment Tribunal's power to extend applies to the time limit extended by the early conciliation process. So suppose the claimant presents the claim on the 28th of September 2014 when the time limit expired on the 28th of August, having been fixed at that point as a result of the impact of early conciliation on the time limit. The Employment Tribunal must consider that the claim is 1 month out of time, as opposed to considering that it was out of time judging from the 28th of August. So you don't use the original limitation expiry date, you use the extended limitation expiry date.